Hi, Mr. Khan. Should an overstayer that is married to a British national apply for a visa from within the UK, or should they return to their home country to apply?
Uh, Good question on that. Spouse, let's assume in this way that they have a marriage certificate. It will be very unlikely that the spouse would get uh, leave here within the UK or visa within the UK. Why? Because they changed law back in 2012. So since 2012, so it is very unlikely unless there are extremely compassionate or compelling circumstances or any child there. Otherwise, just merely basis of the spouse, this is very unlikely. So what we will advise on that basis, that the spouse should leave the country, leave the UK, go back to the country where he came from, either in Pakistan or Somalia or wherever the country or Nigeria, and get a right entry clearance for that. But before he leave, make sure that fulfill requirement, mandatory requirement has to be fulfilled. Number one, income threshold. Number two, there is English test, and number three, there is a marriage which is acceptable by the UK government, and relationship genuine subsisting. And the only one thing is left now: the applicant has, a spouse has valid leave here in this country for switching. As you mentioned, this because he's overstayed, so therefore the person or applicant or spouse has to leave the UK, and no need to wait over there. Straight away application can be made. Other categories like a skilled worker or like other, other categories, whoever the categories, on those category, if someone is overstayed, that person has to wait at least 1 year after being overstayed in that country and then can apply. But in spouse, no need to wait 1 year, straight away can apply. Yes, but another thing is, if someone been, for example, overstayed and left the country and want to come as a dependent of any other category like a skilled worker, the person has to wait for 1 year. If been deported on the expenses of the applicant, then 5 years ban. If been deported on the expenses of the government, then 10 years ban. But this is less, chance that it's going to affect on the spouse of British citizen. So that's the advantage of that. But representation, explanation has to be very clear. The Secretary of State should understand that, because it's a genuine and subsisting relationship.
Okay, thank you, Mr. Khan. Hi, Mr. Khan. Can a child born in the UK get indefinite leave to remain after 7 years? What are the requirements for the parents?
Very common question. Just day before yesterday, we booked the case and we dealt. Uh, Answer is yes. If child born in the UK, regardless the status of the parents, child born in the UK and has been living in UK last 7 years, then the child is entitled for indefinite leave to remain or permanent stay. Same thing. That's the one thing. So what have to prove that? The child born birth certificate of the child, because normally, obviously, child is going to be born in any hospital in UK, so the birth certificate they can get from the local registrar office. Number two, what are the documents required? Number two, that in red book, so that will prove the child born in the UK and has been living in the UK mean. So that, for example, a school document, if child is going to primary school, or if any kind of correspondence between the school and the parents or the child, so that will prove a presence in the child, mean living in the UK. That's the first thing. Second, part of the question is, before I go to the second part, so how long would it take? There's two type of service. One is a fast track service, and second one is standard service. Standard service normally take up to 2 months average. So if we make application to the home office, normally we are getting a reply within 2 months time. And if fast track service, there is extra fee from the home office, then the decision can be made by the home office within 5 working days. It depends on the service, whatever service we choose. Secondly, the advantage to the parents, if the parents are illegal or overstayed, whatever reasons, as far as the parents establish they are the primary carer of the child, so then they also can apply leave to remain on the basis of the child. So they need to prove that they are the primary carer. For example, their name in the school where the picking and dropping and all that. So the whole family can be settled down. Any other child who is not reached to the 7 years but has been living here, is age still under 18, that child also will get benefit of that. So it means indirectly all family would have, or would can or can stay. Can we